So the context for this was the AM2D staff meeting. People said they wanted to learn more about IP, and so we put together this series of seminars geared towards empowering mostly PhDs and postdocs, but perhaps even academics that need a refresher on matters related to IP. So the next session is probably going to be on when things go badly, so case studies on when things go bad and learnings that we can take from that. And then the third session is probably going to be around successful industry collaborations and the ways in which IP was relevant to those collaborations. The other thing I wanted to mention, particularly for the AM2D people that are here, attendance at all 3 events will allow you to earn a digital badge. I've spoken a little bit about these digital badges or micro-credentials a few times, and the benefit of those is that an employer can see that you've done something in this space, and you can put it up on your LinkedIn. Employers can see that, and people can say, okay, yeah, you've had some experience in this. So I hope there's value in that as well. And if you have any questions about that, please do let me know. All right, I think we're ready to begin the main event. I do want to thank IP Australia and the outreach team there for co-organising this event. But in particular, I want to introduce and pre-thank Catherine for coming down. Catherine is a Supervising Examiner at IP Australia. And Catherine has come all the way from, you said, Bairnsdale.
Yep, I think.
So a really long journey to come and talk to you. So please make full use of Catherine's time. Ask lots of questions. I mean, I assume you want people to ask questions. So ask lots of questions. Take full advantage of Catherine being here. And Catherine, I'd like to hand over to you. Thank you very much.
Thank you so much, Philip. I'm excited to be here and escape the tiny country town from which I come to see the big smoke. Even though I didn't even make it all the way on the train, I had to get off a bit early. But good morning, and thank you for taking the time to be here today. As Philip said, my name is Catherine Downs, and I am a Supervising Examiner of the Biotherapeutic Patent Examination section at IP Australia. And I look forward to taking you through our presentation on intellectual property fundamentals today. So we'll be going through the what's, whys, and hows of all things patents, and I hope to add a bit of a research context to that, as well as some tips for best practice, particularly when it comes to commercialization. So there will be opportunities to ask questions at the end of the session, and please note that this session is being recorded. So similar to Philip, I would like to acknowledge the Burrunong people of the Kulin Nations on whose land we gather today, pay my respects to their elders past and present, and I also extend my respects to the traditional owners of the lands that you are all joining from online, and to any other Aboriginal and Torres Strait Islander people here today. At IP Australia, we acknowledge the ongoing contribution to innovation that Indigenous people make. So IP Australia is an administrative agency, and we administer the IP rights systems and manage the legislation relating to trademarks, patents, design rights, and plant breeders' rights. IP Australia contributes to the innovation system more broadly by using our skills and experience to advise government and Australian businesses to make the most of their IP, and also help people like you get a better understanding of how intellectual property might be important. Okay, so we've heard that intellectual property can be many different things, and Australia's IP laws provide a legal framework to protect your creative ideas through IP rights. It's worth noting that IP is a valuable, intangible asset. It promotes investment and stimulates economic growth, which can be beneficial for a business, particularly if you're making one, and the national economy more broadly. So let's have a look at Australia's IP system. As I just mentioned, Australia's IP laws provide a legal framework to protect your creative ideas through IP rights, some of which need to be formally registered and others which do not. At IP Australia, we administer the registered rights. So that is trademarks, patents, designs, and plant breeders' rights. And for a registered IP right to be enforceable, the IP creator or owner needs to be active to gain protection. Other types of unregistered IP protections include copyright, trade secrets, and circuit layouts, and each has its own requirement and rules. Copyright and circuit diagrams, for example, are automatically protected if certain conditions are met. And each right protects your intellectual property and provides benefits in different ways. A good IP strategy will often involve a combination of registered and unregistered rights, and the right combination can provide comprehensive IP protection. And this can be beneficial to your idea or invention in the long run, particularly if you're looking to develop it and take it to market. So why should we register IP rights? I've alluded to some of the benefits in terms of protecting your own ideas. But in registering your IP, it gives you the exclusive right to determine who can use your IP and how it can be used. It gives you the opportunity to sell, license, promote, or develop your product while limiting competition from other businesses or individuals for set periods. IP rights also reduce the chance of your idea being replicated and passed off as those of a rival trader. They can be extremely valuable in opening new opportunities. And a great example of this is that IP rights can be used as a negotiating tool for validation of projects or proof of excellence or relevance when you're seeking third-party funding, or for a startup looking for investors, or when you're licensing a product to be made overseas to expand and establish brands' market share. You might have seen the question asked often on shows like Shark Tank: have you applied for or do you have registered IP protection? Experience in navigating and managing IP rights is a valuable asset in itself for any researcher. IP and commercialization skills can be a vital component of a robust skill set for securing your professional future. Obtaining IP protection overseas is something you should consider doing before or very soon after you file for protection in Australia, even if you're not sure if you want to expand your business overseas straight away. Securing your IP rights in selected countries now may help you to expand in the future. So it's evident that the journey for a startup or an innovator is challenging, and getting the right investment or funding can often be crucial to keeping going with critical research. There are a number of studies which have shown that securing IP rights and setting solid foundations for early stage innovations provides a greater chance of success than those that don't. For example, international studies estimate that patents and trademarks increase investors' estimates of a startup value by around 20%, especially in the early development stage and early financing rounds. And when compared to their peers, Australian firms with patents obtain more of their funding for innovation from external sources than those without patents. So there are risks associated with IP protection, and perhaps more so with lack of protection, that are worth noting. So it is worth keeping in mind that the longer you wait to consider IP, the more significant the risks. It is important to have a well-considered approach to intellectual property early when you've initially developed your idea or innovation, and it can sometimes be the difference between success or failure. So how early? Well, this is where the requirements, particularly for patents and designs, can be complex, and it is important to inform yourself by attending things like this of the requirements and get advice as soon as you feel like you have a promising idea worth protecting. So by considering your IP strategy earlier, you'll be better prepared to manage and protect your idea or innovation. Your invention will end up being protected earlier, perhaps before a competitor can get in, and you can signal your intent to investors earlier, which may help you secure funding. Some other risks regarding intellectual property more general could include the loss of protection. A company may fail to adequately protect its IP, allowing others to replicate its products, services, or brands, and this can result in a loss of opportunity, such as a reduced ability to secure investment or potential loss of your product market share or competitive advantage. This will also impact product sales and revenue. Infringement is something that occurs when a company knowingly or unknowingly uses another entity's already patented intellectual property. If you're found to be infringing on another business's protected IP, you may need to stop commercialization of the idea, rebrand, and destroy stock, which is obviously a huge cost to any business. Further infringements can lead to costly litigation or fines in the tens of thousands of dollars. There may also be risks associated with tech transfer. The risks associated with transferring technology from one entity to another, such as losing control over the IP or sharing it with a future competitor. I'll discuss it later in the session, but this is where options such as an NDA may come into play. So before I chat about each of the registered IP rights in more detail, I wanted to provide an outline of some of the common elements which apply to all the registered IP rights. So you will need to meet certain legal requirements in your application, and there are fees payable. So a trademark starts at around $250 per class and lasts for 10 years, although it can be renewed indefinitely. All other IP rights have a limited protection period. An IP right registered in Australia does not provide protection in any market outside of Australia. I'm going to say that about 50 more times today. And if you find your IP is being copied or used by someone else without your permission, it's up to you to take action against them. So I will now briefly introduce you to each of the registered IP rights that IP Australia administers. I'll begin with trademarks. Often called a brand, a trademark is your identity, and it is used by customers to differentiate your products or services from those of your competitors. And not just a brand or a logo. It may be your corporate logo, a jingle you use in advertising, your business name painted on the side of your truck, or your signage or packaging. They can be a very valuable asset for your business, and they can be any of the following: a letter, a number, a word, a phrase, a color, a sound, a smell, a shape, logo, picture movement, or aspect of packaging, or any combination of these. A registered trademark provides you with exclusive rights to use, license, and sell the mark. You can apply for your trademark by using our pre-application service, TM Head Start, or our standard application online. The initial protection will last for 10 years, but if you continue to pay the renewal fees, it can be renewed indefinitely. Your trademark can be a valuable marketing tool because the value of your trademark increases with the success of your business. And on this slide, we have 3 examples of registered trademarks. The Nike's swoosh and the Penfolds cork are examples of a logo trademark, and the Coca-Cola bottle is a shape trademark. Coca-Cola also have word and logo trademarks. Next, I'll talk about design rights. A design right protects the overall visual appearance of a new and distinctive product. For example, a Dyson vacuum or Apple's AirPod case. And on screen, we have a chair, a handbag, and a dress, all of which are protected with design rights. In protecting the visual appearance of a whole product, it's important to note that the products must have a physical and tangible form, and they must be manufactured, handmade, or produced on a commercial scale. And like patents, you must keep your design a secret until you have applied. This is the other thing I'm going to say about 100 times. Even posting one picture on social media could make it difficult for you to claim a design right and enforce it. Applying for a design right is a 2-part process in Australia, and you will need to complete both in order to legally enforce your design right. Design right protection has a lifespan of a maximum of 10 years. Design rights can only be renewed once, either at any time within the first 5 years of registration, or once the first renewal period ends for another 5 years. Thirdly, plant breeders' rights, or PBRs. They provide exclusive commercial rights for a registered variety of plant together with its variety name. On this screen, we have 3 great examples: a barley species, blush strawberries, and a distinctive flower. PBRs encourage plant breeding and innovation, which means that a large and growing pool of new plant varieties are freely available when the protection period lapses. A PBR is a means to protect a variety of a plant that's specific to itself and things that distinguish one variety from another. All varieties of plant, fungal, algal species, and transgenic plants are potentially eligible for a plant breeder's right. However, only new or recently exploited varieties can be registered. I'll now launch into a deeper discussion of patents, as when it comes to research-related IP, these are probably the most commonly used and the most complex. However, before we dig into them, I want to clear up a common myth. One of the biggest misconceptions is that in IP is that patents prevent progress through a restriction of use and secrecy. Patents can play an important role in scientific and technological progress because they reward and encourage public disclosure of inventive knowledge, which might otherwise stay secret indefinitely. There are two sides to the patent bargain. Patent ownership puts you in control of who and how your IP can be used. But you can also choose to let others use your invention for free in some instances. For example, with free licenses, by subscribing to a patent pledge, or for research purposes. Patents prevent competitors and other market actors such as firms that may not share your values, for example, your commitment to sustainability, from using and benefiting from your ideas. Patents can be thought of as the front door to your house, and they enable you to share the idea to the extent that you are comfortable with. You can let who into your house you like, keep out those you don't, and it supports your business goals. So a patent provides exclusive rights for a device, substance, method, or process that is new, inventive, and useful. On this slide, we have three well-known examples of patented items, such as Google Maps, which was invented by two brothers from Sydney and afterwards acquired by Google, the cochlear implant, and the polymer banknote. Protection gives you exclusive right to determine how your patent can be used and who can use it. Protection of your patent can last for a maximum of 20 years, although in the instance of some pharmaceuticals, up to 25 years. It is important to note that you shouldn't share or publish your idea too soon. If you're applying for a patent, it must be new and inventive over what is publicly available. That's the basic premise of a patent. You are securing a monopoly in exchange for putting your idea forward into the patent system, which will eventually be published. If you want to discuss your idea with employees or business partners, you may want to have them sign a confidentiality agreement or an NDA. If your idea has promise, please be mindful of publishing too early. If you have accidentally already gone public with your invention, you may enter into a grace period, which means that you have 12 months from the date of disclosure to file your standard patent application. Some things to consider before submitting your patent application. Can my idea be patented? If it's clearly a product or process, then you're on safe ground. If the idea is purely theoretical, artistic, or a business method or similar, then likely not. And different forms of IP protection, such as copyright or trade secrets, it might be more appropriate. Some things are specifically excluded from being patented, including human beings. We have more information about what can and can't be patented on our website, but it is worth noting that each country has different requirements. Is my idea different? Applicants should do plenty of research, and it's common for applicants to review their competitors. So I will now briefly introduce you to each of the registered IP rights that IP Australia administers. Each patent office will allow you to search their collection. In Australia, we have AusPat on the IP Australia website. One of the most useful tools, however, is Google Patents. And this searches for patent documents from all around the world and has patents going back many, many years. Just because you can't find a product on the shelf in Bunnings doesn't mean that it wasn't invented 60 years ago in France. So the next two steps often go together. A patent is only needed if you intend to commercialize your product in a market where you consider there is competition and you intend to enforce your rights. If your idea is a new toy for Christmas and your business plan is to hit the market hard, build a strong following, and then wind up manufacturing to concentrate on a different idea for the next year, then a patent might not be the best idea. If you have spent many thousands of dollars on R&D and your product will be in the market for many years and can be reverse engineered, then a patent might be a great idea. Other considerations include which countries you will take your product to, and will you be able to prevent copiers? Do you need a granted patent to secure investment funding? If you are collaborating, then what happens to the IP that you bring into the relationship and who owns the patents that result from the relationship. Professional advice. Now, just as many businesses will employ various professional and specialized services, it can be useful to consider the benefits of a patent attorney. Patent attorneys are lawyers with science and engineering degrees, and they specialize in patents. I'm sure many of you will use a tax accountant to navigate the tax system and perhaps deliver a better return. A patent attorney should deliver the same sort of thing for your patent application. And finally, once you have decided that a patent fits your business plan, you've got advice, and you're confident there are no similar products on the market, the next step is to prepare your patent application and specification so that you can meet the requirements for a granted patent. So what are the basic requirements that you need to meet in order to be granted a patent in Australia? As I said before, your invention needs to be new, inventive, and useful. And new means that the invention needs to be different from anything that was done before. And when checking this, we search the entire world for identical and similar inventions. And this means you need to keep your invention a secret before you apply if you want to be able to protect it with a patent. If your patent idea is already visible to the public, even if you published it yourself, it is no longer new. If you need to talk to others about your idea, you need to be sure that they will not disclose your idea to anyone else. For something to be inventive means that it must go beyond what is obvious given the normal progress of technology. And for something to be useful, it means that it must be able to be made or used by industry. And this criteria ensures that the invention is capable of being applied in the real world. For example, a perpetual motion machine, as far as I'm aware, will not work and therefore may fall at this hurdle. Other legal requirements exist and are assessed on a case-by-case basis or relate to the nature of the specification. And the specification is the document that describes your invention and stakes out your monopoly. So taking a closer look at a patent specification, it is important to note that perhaps at first glance, they can be complex. They are written in legalistic terms and can be full of repetition. So if you do decide to search patents in your field, fingers crossed, this overview will give you a high-level view and help you begin your navigation. A patent specification contains at least a title, abstract, description, and claims. Figures and drawings and sequence listings are optional, but very often they're quite helpful. So the title and abstract are relatively self-explanatory, but the description will usually define the problem that the inventor is solving and define many of the terms that are being used throughout the document, and then describe what the inventor did that is new, surprising, or inventive. It can, in some parts, be very similar to journal articles. Importantly,
Okay, bye, bro.
importantly, in Australia, you cannot add new matter to your description after filing, and the claims or the definition of the legal monopoly must be based on the information in the description. So the level of detail in the description must be sufficient at the time of filing your application. So as I just mentioned, the claims section sets out the boundaries that others are excluded from. And these are supported optionally, as I said, by drawings, figures, and which often, again, look like figures from a journal article. With this basic understanding of a patent specification, hopefully you can approach the published patent literature, fingers crossed, with a touch more confidence. Much like conducting a preliminary search at the start of a research project, it is important to conduct a comprehensive patent literature search before applying for a patent. It's important to note that, as I mentioned, there is a lot of complexity in patents. So to undertake the process, you may need to become familiar with at least a specification and perhaps a little bit of patent law, processes, language, in order to make the determination around whether your new idea will infringe on someone else's. As I mentioned on the previous slide, the claims are what stakes out any patent monopoly, and these can be difficult to read and interpret. but reading a few specifications will help you gain an appreciation for their structure and disclosures. And as always, if in doubt, seek advice. Hopefully, this will give you a starting point. And so if you've searched around and you understand what you might need to include your specification, the next step is to decide what patenting process suits your business plan. So in Australia, there are a couple of pathways that can lead to a granted patent. It's important to be wary of the nuances around timing and the life cycle of each of these types of applications. And as always, further details are available on our website. A provisional application is often a starting point for a patent application. It secures your priority date, which is a bit like a bookmark that says, at this time, I had this idea. It then gives you 12 months to decide if you wish to file a complete application. It's very important to note that it does not give you patent protection, and it is not published, so it remains secret. And if you decide not to proceed with your patent application, then it remains on file and no one else can see it. An international or PCT application is an option to streamline the application process if you intend to seek patent protection in multiple jurisdictions. It provides an indication of whether your patent might meet standards across a number of signatory countries. It does not technically give you protection. You will still need to file a complete specification through what is called national phase entry. However, using this PCT process generates an application into the national office of all the countries that you select. And as such, it streamlines the process for applying for protection in multiple countries. And the complete application is what is necessary in Australia for patent protection. It is effectively the Australian process that follows the PCT application, but you can enter this stream without undertaking a PCT application. Once granted, gives you the right to take legal action against others using your invention in Australia without your permission. It allows you to license someone else to manufacture your invention on agreed terms, and it can be complex, and once again, you may need assistance to apply. At IP Australia, we manage all these processes for Australia, and we employ the examiners who assess your application against the criteria that I mentioned earlier. So this is a timeline that shows the process from the filing date of a provisional patent application on the left to granting a valid patent on the right. Once again, highlighting that it is imperative that you do not disclose your invention before filing. It will take some time for the patent to be examined and granted, but the IP may be assigned or licensed at any time during the course of its life, including before creation of a commercial product. However, a patent can only be enforced against potential infringers or copycats once it is granted at the end there. A registered patent in Australia will only cover you here. When aiming to enter different international markets, you will need to be aware of the legal requirements and processes in those jurisdictions. And you may wish to use the PCT. You can see in the timeline that both pathways can lead to a registered right that is enforceable in Australia. If you want to learn more, please check out our website. I feel like I might have covered this. But to be eligible for patent protection, your invention must be novel, and the prior art includes any information made publicly available before the priority date of your patent application. And so keep in mind that each of the following disclosures may count against you, and they include written disclosures, including physical and digital publications, oral disclosures, including in-person and online presentations, actual display or use of the invention in public. So keep in mind that the same material can be patented and published as long as a provisional application is filed first. And journals are increasingly making publications available online before their stated publication date. Grant applications are generally not considered public disclosures, but the title and abstract may be published online if you are successful. And discussions with collaborators or industry with a full confidentiality agreement should not be should not be detrimental to subsequent patenting. You may also want to avoid publishing anything that may make your invention obvious. And the place where this happens most often is in the future work section of journal articles, where it is common to discuss hypotheses or research plans. So it's very easy to come up with an idea. It's a lot more difficult to make value from that idea. And SMEs and inventors need to know how they are going to make use of their idea as part of their business plan. And that's why we talk about IP strategy and commercialization. So commercializing your IP means extracting value from your IP by marketing a new product, production or method or service based at least partly on your IP. And IP protection can reduce the risks of commercialization by deterring competitors from using your innovation without your permission. It also helps you secure and extract value from your innovation on each step of your journey to realizing your innovation in the market. So there's a couple of key considerations for commercialization, and they are listed on the slide. So I don't need to read them out, and I will skip forward. It is important that, as we said before, you need to keep an eye on what your competitors are doing, what other people who are applying for IP are doing, and we have free databases that you can search and check up on your collaborators, competitors, anyone else who's operating in the same field as you. So that can act as an early warning system that you might be infringing. You can sense if they're stepping on your territory that you intend to go to, and it may help you understand where your freedom to operate is. Non-disclosure agreements can work as an interim before you file for IP, or if appropriate, respecting what your business plan, commercialization plans are, they can apply across the life of a secret. For example, a trade secret you may want to protect for many, many, many years beyond what a patent would provide, and you don't want to publish it, and therefore an NDA might be the right thing for you to consider. IP Australia has a contract generator on our website, which is a good place to start if you wanted to have a look at one of these or think about kicking one of these off. I want to give a huge plug to technology transfer offices, and the one here at Monash is pretty good, I think. So these will help you, and perhaps as university researchers, it will be your first port of call. I've had this amazing idea. Is it worth anything? Should I think about patenting it? Can I go to this conference in 2 weeks? Here's the talk I've already submitted. Those sorts of things, they are very happy to help you with. As you can see here, you may want to submit an innovation disclosure form, in which case you will need to think about who owns the IP that you are about to discuss with the technology transfer office. If you're part of a collaboration, you may not own it entirely yourself. You may be a part owner. So often researchers undertake partnerships and collaborations, and it is really important to understand the IP that is involved with those. So background IP is the work that's created outside of the collaboration and belongs to one party before the collaboration. Project IP is new IP created during the collaboration. And third-party IP is existing IP that's owned by someone not involved in the collaboration. But it's important to keep in mind that different types of IP might apply at different sections of your commercialization or partnership journey. And if you are working on a new product and subsequently come up with a new manufacturing process, they can be subject of different patents. And what's most important is determining who owns the idea and who is responsible for patenting the idea. So I really go on about this for quite some time, that it's really important that you know who the owner is and who's responsible for managing the IP. In Australia, IP generated through the course of employment is typically owned by the business, except where it's specifically spelt out in the employment contract. However, at university, there will typically be an IP policy, which determines ownership for staff, students, honorary appointees, and even visitors. It's worth noting that IP policies, such as those at universities, may typically specify a duty of disclosure. and that is that you have a duty to disclose to the uni any IP that you create with doing related university activities. And I would encourage you to read your IP policies and engage with your commercialization office to make the most of your IP. Another point that I think is important for researchers to be aware of is that sometimes a materials transfer agreement may be necessary to transfer physical materials between research groups or collaborators. And it involves situations where an IP owner agrees to provide their IP to another party. For example, where a company provides a strand of mRNA to researchers to conduct further R&D. And such agreements may typically require the party receiving the material to assign ownership of any new IP to the original owners of the product that they were receiving. So what matters the most is how this all fits into the big picture. And what you really need to figure out before you start on your IP journey is where you want to end up. What is going to be your end goal or outcome in the context of your idea or innovation? Do you just want to do more research? Do you want to take this all the way to market, commercialize it, and turn yourself into a billionaire? Whatever path you choose, you need to design your commercialization strategy and understand enough about IP such that you can achieve your dreams. So the take-home tips that I have for IP management are: consider IP early, identify who owns the IP, speak to your commercialization office, and learn how different IP rights can work together to protect your idea. And when you register your IP, it will be published online. Before that, design rights and patents need to be kept secret until you apply. And if your product has a short lifespan, then there are alternative strategies that may not include registering your IP. Have a strategy in place to identify what steps you will take to find someone copying your invention or using it without your permission. As I said earlier, IP Australia is not involved in IP enforcement, and a registered IP right does not give you protection outside of Australia. If you plan to commercialize internationally, you will need to seek protection there, and do not be afraid to get help. It can be tough turning an idea into a reality, and IP Australia is here with general advice, and Technology Transfer Office, Monash Innovation, is here for more general and specific advice. I was going to leave you with a cautionary tale, which I will briefly talk through because it leads into your next session, I think, in that inventors Ryan Tilley and Hugh Nguyen came up with an innovative idea to allow wheelchair users to access the beach and other off-road areas. Their product was developed through designing, prototyping, and 3D printing sections of tyre. The team saw IP protection due to the simplicity of their product, as they feared it was easy to replicate. They also wanted to protect their identity and brand and ensure that customers had a quality product. So given the stage of their business was at, they were advised to apply for a design right and not a patent. However, 6 months later, they were in a position to apply for a patent, only to discover that their design right registration had come up as prior art. So the lesson here is to understand the full picture of the IP rights landscape and build that into your commercialization journey with your eyes on the vision you want to achieve at the end. And at IP Australia, we are here to help you navigate the IP system. So if you would like personal advice, we cannot help you. But if you need general advice, when it comes to managing and navigating the IP system, it can be tricky, and we understand that, and we are here to help with various tools and contact points on our website. So that's all I had. Hopefully it wasn't too fast at the end. But if you would like to fill in feedback, I would welcome any feedback that you have for the presentation that I gave. And in the meantime, I'm open to questions.
Cool. Join you up here so I can talk where necessary and look at the screen. And when you're giving feedback, please just ignore the technical issues. You can blame those parts on me or Monash, whichever one you prefer to direct it to. So yes, we will run a Q&A session, and what the way that I'd like to do it, just to start with, by the way, we'll go till about 10 past to make up for the technical issues we had. So I understand if some people have to leave, please do so if you have to. But what I'd like to start off with questions is for AM2D people to please start the questioning. I'd like to give them priority, as this is technically an AM2D event. So I'd both, for people in the room, you can just pop your hand up. For people online, just pop your hand up online as well, and then I'll direct you to unmute yourself at the appropriate time. So any questions initially from the AM2D group, either online or in the room? Okay. Yeah, go ahead.
Thank you for your presentation.
So sorry to interrupt you. So because of the technical issue, people here won't be able to hear. So ask the question and we'll repeat it upon answering it.
Yeah.
Yeah.
So I've seen, like, in some places, especially in research and stuff, that results can be replicated when you change certain parameters. It's not much, but then can you call that, like, if something is already patented and if you change small thing, can someone else patent that? Like, the first thing that comes to mind, like, in an everyday example, is like the Big Mac sauce at Macca's. Like, I've seen, like, commercialized products in Coles and stuff that actually, like, give the same taste and the same stuff. So essentially, I'm asking, like, how much of a difference does something have to make to be commercialized, even though it has, like, the same? It basically is the same product.
So the question was how much of a difference from invention to invention does there need to be for it to be a new invention? And the example given was, did you say McDonald's sauce?
Big Mac.
Big Mac sauce. There's various types of Big Mac sauce. How much different does a Big Mac sauce have to be to constitute a new invention? Is that correct, what I've said? Yeah.
So the test that you're talking about is a test that we as patent examiners undertake, and it is to determine whether there is an inventive step. And so you're right, not just new, it needs to be different. And one of the things that we think about is, would it have been routine? And would the person who works in this area, would they be motivated to make this change? So I work in medicine, so I'm really sorry. That's where all my examples are going to be. But if you have a medicine that you can only inject, that's not a great experience for the patient. And so there is inherent motivation to make that an oral tablet. People can administer that at home. And so there's motivation to do that. There would be routine ways in which you could do that. And so small incremental steps like that are unlikely to overcome the bar of inventive step. A marker of inventive step can be something really surprising. Like if you are doing routine things and you're like, whoa, I did not expect that to happen. That's synergistic, or that's really quite out of what was expected in the art. That may be indicative of an inventive step. I think also maybe mixed in with the Big Mac question is the notion of Aldi using trademarks. And so I don't work in the trademarks area, but there has been some recent court litigation as to what is different enough, because I think most of us would walk into Aldi and understand what they're trying to do. And so then it's up to the company who is being infringed or potentially infringed to decide, is it worth me pursuing this?
Did you have a follow-up question at all?
No.
Yeah, awesome. Excellent, thank you. So I just want to prioritize AM2D people first. Is there any other AM2D personnel that wants to ask a question either in the room or online? If you're shy to talk, for people online at least, you can type it if you want to. Just give you 30 seconds to think about that. for AM2D people? Okay, no, okay. It looks like they might come back to it in a minute. So I've got one question online from Arafor Rahim. So Arafor, can you unmute yourself and ask your question, please?
Yeah, thank you. Thanks, Catherine. Nice presentation. So I am coming from chemical engineering background. And my question is that let's say you develop a material and did not realize its full potential in terms of diversity of its applications. For example, if you discovered graphene, then you patented graphene for some conductive coating, but nowadays graphene is also seems to be working quite well in membrane technology. So my question is, when it is patented for a particular application, can this same material be patented for another application? And does this need to be a separate patenting process? And is there any complexity around this?
Just in case the audio wasn't picked up for the recording, I'll just repeat the question as far as I understood it. So I think the question was, for example, if you've got a material, say graphene was used as the example, but it's got various different applications, how do you manage a situation like that in terms of intellectual property? Is that correct? Did I capture that correctly?
Correct.
Yeah.
Correct.
Excellent. Thank you.
So the short answer is yes, you can have different patents for the same material used in different ways. So the original patent may be to graphene as a material per se. I don't even know how to describe it. You can include the chemical structure as part of your claims that set out your monopoly. And then perhaps a later patent, or within the same patent, you have various claims about the way that material is used. And if you are researching graphene and you find a new and very different, very unexpected use, then even as a different researcher who is not involved with the first one, you should be entitled to stake a claim on the monopoly of the use, only the use, not the material per se, that you have discovered.
Sorry, can you just clarify the last part that you said? I didn't get it completely.
So any subsequent patents will not be able to relate to the material per se, so the material by itself. There will have to be a use of that material. So your monopoly will only extend to using it in a particular way, whereas the original monopoly will extend to the material itself. And in order to enact your invention, you may need to seek a license from the original owner.
Thanks, Catherine. Does it mean that the other person who is using that graphene, not from the original one, but using it for a particular application later, does it mean that it has to be articulated in a different way? Are you like when trying to patent that particular application with graphene? Or because you are saying that the materials can't be included because that's already been patented, right? But the application can be. Then how do you write this?
So the claims would be written as a method of using graphene to achieve the outcome?
Yeah.
Does that make sense?
Yeah. So more of an application-oriented patent rather than the first one is more like materials-oriented patent, and there is no conflict here.
Yes, that's correct. So the first one might read a composition comprising this chemical structure, which relates to graphene, full stop.
Right. Thanks, Catherine. The reason why I ask is the language is always pretty foreign to us, especially to academics here. So thank you.
It sure is.
Thank you.
Awesome. Thank you very much for the question. We have one written question from Mohan. Mohan, I might get you to elaborate, but I'll read it out. The question is how to start the conversation and who should be reached. Perhaps, Mohan, you could elaborate on which stage of the process you're talking about.
Yeah. Thanks, Phil. And Catherine, it's a fantastic presentation. Thank you so much for educating us. A very important aspect. So this is, again, a lame question from a very basic standpoint, if you may say. So how do we kickstart the process? Say, for example, if there's a student who is attending and trying to understand the whole process, how do we and where do we kickstart the entire process of patenting an idea or a product?
So as a researcher or a student, you are incredibly lucky in that you have access to Monash Innovation. And if you go on their website, you can request a meeting with a commercialization officer, and you can then sit down virtually, I presume, with them and explain your invention, explain your ideas, explain where your research is at, and they will talk you through what comes next and what the options might be in terms of applying for IP protection or doing a bit more research because you're not quite ready. They can help you with all those sorts of questions.
Was that okay, Mohan? Did you have a follow-up?
No, that's good, because a student was asking, so I think a student also is attending. So I thought if he or she is feeling shy, I'll ask for them. So, thank you.
Thank you, Mohan. There's time for, let's say, 2 quick questions or 1 long question, depending on how we go. So did you have a question yet? Please.
If someone found a specific device online, which is particularly available for patent or whatever, but use it for a completely different application, can the new application with the same geometry or same device be taken for them?
So the question was, if you come across a device of some sort that already exists, can you make amendments to that device and subsequently put a patent together on that basis? Is that accurate? For a different application, perhaps. Yeah.
So in general, short answer is yes, as long as the use or the new application is different enough from the original application. But as with the graphene example, any subsequent patents will need to be limited to the new application, like a method of doing this, a method of achieving this, rather than this device per se. And if the patent, or if there is a patent on the original device and that is still in force, then you may need to seek their permission to sell that device if you haven't made substantial changes to it.
Please. Last question, unfortunately, but yes, please.
Yeah, in terms of student retention, so there are clauses when you sign on to be enrolled in Monash, they will be automatically assigned to the university. So is it like a common practice in the world in terms of the assignment of the IP, where the student come up with an idea, and at the end of their student experience in Monash, they will have to sort of assign the IP to the Monash first, and subsequently I think whatever share the details. Is it a common practice in the world in Australia in terms of what's doing in Australia?
So the question is it common practice that a university assigns intellectual property that's from a student to the university?
Yeah.
That's the question? Yeah.
I believe so. I don't want to speak out of turn, though. This isn't really my hot expertise. But I think in general, there are agreements such that any research that it might be different between students and researchers. And I'm not sure where they draw the line, but my understanding is that for most student projects, if you make IP, then Monash has the first rights to it. Often you can negotiate and get a cut or a share, but that may be spelled out in your IP policy, which I didn't read before I came, sorry.
What I might do on that, I actually predicted that question might come up. And I tried to get someone from the Monash Research Graduate Office to come and actually just 30 seconds, just say this is what happens at Monash, and whether or not it's typical, because we've got people from University of Adelaide and maybe QUT and a couple of other universities online because they're part of the hub. So I thought that might happen, but they couldn't make it, unfortunately. So what I'll do is for the next session, I'll arrange to ensure that there'll be a Monash person there that can, in the first instance, answer that question. But the next session will have people from other institutions anyway, I'm hoping. That's the plan. I don't want to just focus on Monash. So hopefully that question can be addressed more clearly at that time. Yeah, so I'm sorry it wasn't for today. It made sense for today because it's like a 101 type session, but it just didn't pan out time-wise. So yeah. So look, thank you very much, everyone. Please give a really big round of applause, because Catherine not only spoke so well and gave us so much great information, but had to deal with all these technical issues. So please thank Catherine very much. Thank you. I'd like to thank IP Australia again. I think they're still online. So thank you for co-organising the event. And thank you to our audience for being involved.